take that property. On the other hand, if it's an irrevocable trust, if you state, I, Joe Blow, irrevocably transfer my bank accounts and my real estate to Bank of America in trust for the following beneficiaries, then you have absolutely no control over that trust. I mean, as a practical matter, Bank of America is going to listen to you. For example, if you want stock invested, particularly if you call them up and say, I like this stock, I'd like you to put some of the money into this particular thing, Bank of America will probably honor that and do what you want to. But you can't just dissolve it anytime you want either, which is, that's a big factor. There are ways of unwinding an irrevocable trust, but it usually involves getting consent from all of the beneficiaries and jumping through all sorts of hoops. Most people don't get involved in irrevocable trusts. I mention it just so that you'll know that there are alternatives. If you want to completely protect property, then the answer is an irrevocable trust. On the other hand, a revocable trust, which most people need and should have, does not protect your property from creditors. That isn't the reason for a revocable trust. The number one reason for a revocable trust, and we talked about it a minute ago, I said I'd get to this, is the fact that a revocable family trust will avoid probate. It doesn't go through probate. If a will does, any will go through probate, and that's a nightmare. It's expensive because not only do you have to pay an attorney usually to do it, but whoever is the administrator gets a hefty portion of it. So if you have 3 kids and you name one of them the administrator, right off the top, that one that is the administrator is going to get a hefty chunk right off the top. And so you try to avoid that. Something I'm forgetting here.
Irrevocable?
Well,
That's what it's called.
a trust is not probate. That's why you have a trust, because everything is written out. The trust is usually 25, 30, I've seen trusts sometimes 50 pages, because the trustee is given very, very explicit instructions as to what to do when you pass away. And another thing that I always put in my trust is that there's a provision in there that if, typically, when you set up a trust, you are the trustee. You stay the trustee, so you have absolute total control over everything. But you may become incapacitated. And so I put a provision in my trust that if 2 medical doctors, say that the trustee is incapacitated, then the successor trustee, who you also name, will be able to come in and take over the trust temporarily, pay all the bills, do what has to be done, sell property, do whatever needs to be done with the estate. They can come in and do all that, and then when there's recovery by the trustee, if there is, and hopefully the trustee recovers, get 2 doctors again to say that the trustee is okay to go back, and everything's put back the way it was. But that too is not available when you just have a will, and if you have nothing and a parent becomes incapacitated, usually the only choice is to get a conservatorship, which again is very, very expensive and cumbersome and hard, but all that is avoided by a trust. So trust, I charge about $1,000 usually for a trust, which is just a fraction of what a probate will cost you, just a tiny fraction. And if nothing else, it organizes your life. It forces you to put everything in its place, dot your I's, cross your T's, and chances are good you're going to grow into it. Hopefully property is going to become extremely valuable again, and although you don't have a whole lot of money now, hopefully 10 years from now your estate will be double or triple what it is. So I think you don't know what you don't know, so maybe I'm missing something, but I think I told you everything that you need to ask questions about with respect to trust. Is there anything that comes to mind for the rest of you? You have something else? You're very timid, just, well, and.
No, I have a question about the trust.
Go ahead.
Okay, example, somebody purchased a property, a sole owner, and then put it in the trust, recorded, but now he wants to get out of recorded trust, he wants to put his kids as joint tenants. I asked the escrow officer, can he do that? He said, oh, but the wife already quit claim. The escrow officer said that in order for the kids to be in the title again, title now, that wife has to quit claim again, but she already did quit claim.
Quick claim, what?
Before the purchase, to purchase the property.
Well, title companies, you know better than I do, they're often very, very picky. They require things that are not really legally necessary. Now, if she quick claimed her interest in the property, then unless, and the only thing I can think of is that if they live together as husband and wife, then there's a possibility that she gained some interest in the property as a community property interest. Because if he used his salary or paycheck, which is community property, to make payments on the house, then each month she's going to gain a little claim against that house. So I can see how the title company would want to protect their interest and get another quick claim from her.
Oh, they never
But
lived there.
they never lived, it was income property?
It was rented to
It still
the
makes it,
kids.
it still makes it bulletproof.
It was rented to the kids?
Yes.
Okay, did
That's
they?
why he wants to put the kids there.
Okay, and,
Title.
but it was in a trust?
It's in a living trust.
Okay, and was the wife, did she have anything to do with the trust?
No, none, I don't know. She already quit them before the purchase.
Okay, well then,
She's the second wife,
okay.
not the real wife,
The
not the original. Right.
Just adjust the trust? Change the trust?
You changed the trust,
No,
but
she's
she's,
never in trust. She's never in the trust.
right, but the property was.
The property.
Right, and now it's going after the kids.
No, he wants to put the kids.
Yeah, I would say the title company is being overly cautious, but
Yeah.
the quick claim deed is no big deal.
So
No.
that's why he can always take out, put it on title because the kids, right?
Well, the trust would have to do that because the trust owns the property. When you set up a trust and you put property into the trust, you actually record a deed that says, I, Mark Prather, transfer this piece of property to the Mark Prather Trust, or to Mark Prather as trustee of the Mark Prather Trust. And so that you would do that, and then the property is in the trust.
The trustee has to sign off.
And right, and so there's lots of ways to handle that, but
But
if
he
all.
can do it, right?
Oh, sure.
He can do it.
Yeah,
He
you can
doesn't
do
need
it.
a-
That's-
a big claim.
That's the beauty of having a trust, you can do anything you want to, anything that's legal. You can do it, there's a way to do it.
All he wants is to put his kids in.
Yeah, but if it's in the trust, they're already going to pay it if he passes away, if it's worth it.
He should leave it in the trust.
Why is that relevant?
The trust.
He should leave it in the trust, and he should amend the trust to do it any way he wants to.
Otherwise,
And that's why, another reason for having a trust, if you have your real wife and then you get another wife, another wife after that, then it's all still in the trust. And nothing changes. The trust doesn't change. But one thing that, and I was telling Mark this the other day about, horror stories. Yeah, and this is not something that, well, I mean, it could apply to you personally, but I'm sure that, isn't it true that you deal a lot with, you're selling real estate because there's a divorce involved? People get divorced or separated, they want to sell the house and buy the property and so forth. Be sure that you advise your client that to get all of their estate issues resolved and make sure that they look at that. I've been practicing law now for 40 years, and I'm sure I've made a million mistakes that I didn't even know about it. But I know one in particular that I out and out committed malpractice. Fortunately, nothing came of it. But I represented a client in a divorce. He was actually divorcing his wife. And statute of limitations.
This is on camera.
This was long time ago.
This is being recorded.
But I want to make it personal because I want to impress on you how important this is. I was handling his divorce, and this guy was one of the most together people I've ever dealt with. He owned an insurance company. He was an incredibly sophisticated businessman. He was meticulous. His records were, they were just a dream. I asked for whatever it was I needed. I got it in tabbed and, just everything. So it just never occurred to me that he hadn't taken care of his estate plan. Well, he had a will, and his wife was the beneficiary of the will, and they were getting divorced. And some divorces are friendly. This one was not. He hated that woman more than he hated anybody in the world or anything in the world, but he didn't change his will. And before the divorce was final, he and his new the real wife was okay, but he had a proposed new wife. I don't remember now whether they were engaged, but they were talking about engagement. They were girlfriend. Well, they got on a motorcycle up in Lake Tahoe and wrapped themselves around a tree, and the man passed away. My client, who I did not tell to check his estate. This woman that he hated more than the devil himself got $1.4 million that he would have wanted maybe go to his girlfriend, soon to be fiance, or at least to his mother and his brother, or the Humane Society before this woman that used to be his real wife. So it's very, very important. Be sure that you mention whenever you deal with people that are being divorced, they will thank you. They will be very, very grateful if you help them with that issue. Fortunately, I haven't said that very much. And I have no pride. I say I don't know all the time.
Because I heard there was like a provision in some trusts that even if a property isn't vested in the trust, that it still is included in the trust. But
well,
I'm not sure if that's just
now that you mention it, when I set up my estate plan, there's three components to it. There's the trust, there's a durable power of attorney for health care, and there's a pour-over will. And the pour-over will, the reason for that is that if for whatever reason you have somehow forgotten to put something into the trust, that will put it into the trust. And so under those circumstances that you named, probably that would solve the issue.
You said
Thank you.
A pour.
I didn't know that.
Okay.
It pours over. It gets its name from it pours over into the trust. Sure.
Can I have both homestead and living trust in my property?
Sure. And you absolutely would.
Because somebody said your property is living trust, you can have both.
In a revocable trust, that's true, but as long as it's a family trust, you still have a homestead.
Where can I go to get homestead?
Well, you can go on the internet and print off a form. It's a one-page form that where you used to, you could go to stationery stores, and you probably still can. Or you can go to your title company, they'll give you a homestead form.
And
It's
you
just
probably
a,
have to record it?
and then you have to,
You
yeah.
probably have to record your homestead and living trust.
I told you, don't record your trust.
Only half.
Oh, well, okay.
So I wanted to do a homestead.
I wonder if there's, you can just do your homestead, report your homestead.
How do we get a hold of you if we need you?
Yeah.
This is all, I didn't bring a single business card.
I will shoot an email out with him.
Maybe just PayPal account.
Yeah, just call me. Remember the Cisco kid with an S.
Cisco kid with an S.
All right, let's thank Kevin for coming out. All right.